Hi, I'm Reed Bloodworth, Managing Partner of Bloodworth Law with offices in Orlando and Winter Haven, Florida. Bloodworth Law serves as counsel for Florida businesses for all sizes across our state. Our employment law team can work with you remotely via video conference or in the office with the appropriate safety measures taken to protect you as we help you with your legal issues. Today, I'm going to talk about 5 ways to help businesses clarify who's an employee versus who's an independent contractor. Number 1, have an actual written contract with your independent contractors. Legally, a contract can be oral. So there's no rule that says as a bright line that if there's no written agreement, you can't be an independent contractor. What the law says is, one of the things that helps to prove that someone is an independent contractor is if that contract is in writing as opposed to being verbal. So it's better to have it in writing. The second thing is to make sure the scope of work is clearly defined in the contract in as much detail as possible. And the most important factor in that scope of work is who's in control of the time, the place, and the manner of performing that work. So make sure that the scope of work, the time, the place, and the manner in which the work is being performed are clearly set forth in the contract. And that the contractor, not the company retaining them, has control over those factors to the extent possible. The more control the contractor has over these factors, the more likely it is that the contractor is legitimately classified as an independent contractor and not an employee. The third thing is to review those classifications with the latest Department of Labor and IRS guidance on a regular basis. The standards for what is and is not an employee is technically different depending on what law you're looking at. For example, what constitutes an employee for workers' comp purposes? What constitutes an employee for the purposes of minimum wage and overtime? What constitutes an employee for the purposes of harassment and discrimination? And what constitutes an employee for the purposes of the IRS? These are all different standards, but they are very close to one another. Looking at guidance from any of those different sources is useful for helping make sure that you've shored up with all of those. The IRS in particular has a very detailed questionnaire that you can use as a worksheet to figure out if someone's properly classified or not. So that's a great place to start. The Department of Labor also provides some guidance on that. Reviewing these policies and what they do, and reviewing your personnel and how they're controlled is a very good way to ensure your business is properly classifying its employees and its independent contractors. Also important is to do this review regularly, not just at the front end when someone's hired. If you have a written contract, it's not something that's going to last forever. It has an end date, and that is one of the factors. If somebody's retained for a year, say as opposed to indefinitely, that's more indicative of a contractor. So if it's an annual contract, which it probably should be, or something that's periodically renewed, then that's a good time to review the guidelines from the IRS and the Department of Labor to make sure that this classification is still valid. Fourth, consult with both an accountant and an attorney. An accountant is more likely to be up to speed on the IRS issues. The attorney is more likely to be up to speed on the other employment statute issues. So for any special cases, you can save yourself a lot of trouble if you just ask for advice on the front end as opposed to asking for advice after you get served with a lawsuit, which will cost many thousands of dollars. In addition, if you've got the advice of an attorney and or an accountant on the front end and followed that advice when you were making your decision as to how to classify someone, that could help you save money even if you were wrong, because showing that level of effort to do it right helps reduce your damages in the event of a lawsuit. Finally, number 5. When in doubt, just hire them as an employee. It's not worth the risk. Legal consultations with an employment attorney to review your employment policies, your independent contractor contracts, can ensure you're in compliance with Florida employment law. I hope you found this video helpful. Again, I'm Reed Bloodworth, the managing partner of Bloodworth Law. Let's talk about how Bloodworth Law can help you, your employees, and your business.